And now it's time for the discussion segment. Of course, we're looking at Nigeria's judiciary this morning. Of course, reform, that's what comes to your mind. But I would like to ask, what comes to your mind when you hear about Nigeria's judiciary? Is it all about reforms, or you're talking about something else, or you think about something else? Anyway, this morning we will start with this, and then they said the corruption and undue influence are eroding the foundations of our judicial system. And this is what was opined by the Chief Justice of Nigeria and Justice Olukayode Ariwola during his remark at the National Summit on Justice in Abuja. And then the President, Bola Ahmed Tinubu, of course, the number one citizen of the country, said that he has urged the judiciary to initiate reforms to support the nation's growing economy as well. So the CJN actually emphasized the importance of addressing systemic issues such as corruption, inefficiency, and undue influence to uphold the integrity of the judicial system in Nigeria. But of course, to talk about the judicial reform, Nigeria's judicial reform, we're being joined by a senior advocate of Nigeria, Barrister Sam Kargbo, to analyze the judicial, system and then the reforms that we are talking about. It's always a pleasure to have you on the show. Good morning to you, sir.
Thank you very much.
Like Uncle Sam, like we like to call him.
Thank you.
Now, looking at the judicial system in the country, at every valedictory session, at every time where we have the MBA summit, we have the MBA conversation, we have lawyers coming together, we have anything to do with judiciary or justice system in the country, judicial reforms is at the forefront of all of the conversation. And now there's been a recent call to let's say reform the judicial system in the country. And now the first question I would like to ask is, what has changed so far in the country's judicial system, talking about reform, and how far so far? Yeah, basically.
Let me start by saying that the judiciary is the most important arm of government, because it is actually the one that you would say is the last hope of the common man, meaning that when all is lost, there is always a place for you there for you to get a relief and solace. And therefore, we, the legal practitioners, and almost everybody out there who knows the importance of the wheel of justice, would always emphasize on the need for the judiciary not just to dispense justice timely, what you call speedy dispensation of justice, but also the justice that they dispense should resonate with the people. Let the people at the end of the day say, yes, justice has been done. So it's important, and the only way you can get that product, because it's a process that produces justice, is for the machines, which is the procedure itself, to be just. And that would start with the appointment of the judicial officers itself, how they are appointed, the caliber of people they are appointed, the personality of the people that are appointed, the character of people that are appointed. Yes, you would say that should ordinarily not have been a problem, because they are an elite class, because they are appointed from among lawyers. You must first and foremost be a lawyer before you can be a judicial officer of a court of record. And you must have attained certain years. For an example, you can't be a judge without having been called to the bar for 10 years, for the past 10 years, and you would have had had experience in practice and in the judicial process itself. So that should never have been a problem, because if you have people appointed from that class of people, obviously you would have expected that they would come with some sort of moral and ethical standards that should ordinarily be above par. But as anything about the Nigerian, there is hardly any class of people or class of elites that has not been affected by the malice. So most of the time, what we bring in, irrespective of that shiving system, irrespective of that delicate process of making sure that those who are recruited in come in with above average standard, we still have some what I would call, I don't know if that's the right language, bad eggs from among them. But I would say this, and I've always been saying, so people would wing, but I would say so. Of the three arms of government, the judiciary has had better output in terms of surrender value. When I say surrender value, what they give to the public in terms of standard, quality, and moral standards.
So how would you rate that?
Than the other.
Why would you rate that for the past 1 year in this administration? I mean, the judiciary as a whole.
Yes.
How has the reform been in the past 1 year? Has it improved? Are we seeing something different from what we've never seen before in the judicial system in the country?
Well, it's difficult because it's a case-by-case sort of assessment. If you want to ask me to have a panoramic, then that will be a difficult one, because the judiciary touches every aspect of the country. You have them all over the place. Yes, basically, some of us tend to respond to limelight cases because those ones are the ones that the public have their eyes on. But for every one of those ones, there are 1 million one of them that are going on smoothly. But most times, political cases come in with their own characteristics and their own interpretations. So when we tend to characterize or judge or assess judicial officers from their own intervention and interaction with political cases, sometimes we get a little bit unfair to them. But if you ask me, the judiciary has come a long way. But like I'm saying, the society is evolving, and the standards of yesterday that were okay, today not acceptable. So they have to actually also act up and access the new world standards. So that is where we as practitioners are saying, hey, every year we take a look at the assessment of the last year, issues that have come up, and we tend to lend some sort of experiential discussions to say, perhaps if we go this way, we may be able to attend to this, because there is still this problem of backlog of cases. Great. It's a problem. And yes.
Sorry to butt in. I'm glad that you mentioned experiential discussions and backlog of cases. You're a learned senior advocate of Nigeria, which means you've seen it all in terms of cases and some of the challenges and bottlenecks that might impede the delivery of justice. So perhaps you could tell us some of these issues on the spot via experience that you have encountered that would make you feel like perhaps if these reforms should be done, spotlight should be on these issues because it has impeded your work as a man of the judiciary.
First and foremost, let's look at the impact of political cases on the system. Whenever you have a round of elections, almost all courts are depleted because the election tribunals are going to be empaneled by judges and magistrates drawn from the courts across the country. And when that is done, all the cases they've been attended to, they would have to wait for 6 months minimum. They would have to wait. Be they human rights cases, be they criminal cases, irrespective of the urgency in those cases, they are put at bay. And because you do not say because somebody has left, you draft in another judge to come and deputize. No. Every judge has to handle the case from the beginning to the end. If a judge tries a case halfway and he's elevated or is transferred from that place to the other place and to the point that he can no longer handle it, the next judge coming has to start de novo. So usually what happens, once they are gone, those cases are put at bay. To me, that is a big problem, because justice should have a uniform standard, and the attention to justice and the machinery of justice should be standardized, not one that is tended to address a certain aspect of the society. Yes, politics is actually a serious business, but I do not see a justification whereby you halt the entire wheels of justice regarding all other sectors, and you deploy all the energies and human capital to the political cases. To me, we have to go. I'm coming back.
Okay.
To me. Then second, and which for us lawyers, and if you listen to most of the discussion, that's where it's going to, the procedure. Our adversarial system and our adjectival system, what I mean by adjectival system, our civil procedure, criminal procedure that we use to administer cases, to process dispute, are cumbersome. And by themselves, irrespective of the efficiency, irrespective of the focus and dedication of the judex, they consume time. They consume time. The civil law system, we call it the inquisitorial system, which is being used by the majority of countries in the world. We, the adversarial system, are those of us who have the baggage of the British colonial system, plus America. We, just about 51. That system by itself gives you that presumption, fallaciously, that, oh, you are innocent until proven guilty. Now, I have a governor who has left office, who has had, say, ₦1 trillion coming into office, but has not spent maybe 300 million. But we know the money has come in. We know that nothing has been done. And he's gone. The money is not there. The lawyer is going to say, yeah, something is wrong here. Like they say, oh, Gary don't pass water, or water don't pass Gary, right? But the lawyer is going to say, yes, if you have any suspect, that suspect, irrespective of this glaring circumstance, is what? Innocent until proven guilty. And here is what it is. Anybody who has money and has power has the war chest to employ the best of lawyers. Against what? A government system that is spread wide and thin. There is no way you are going to put the private sector lawyers against the government lawyers. That is a war already won by one side. And this big man thief is going to come with that war chest to the system, and is going to employ everything within his means to make sure that what? The wheel of justice grinds slowly for his own benefit. It's going to do that. But here is what happens in the other system, and I will give you the story. A friend of mine who was working in Ethiopia at the EU, he wanted to leave and wanted to give some of his things to the house helps, or the house helps.
Housekeepers.
The housekeepers. And when we were picking up the things, they were saying, where is the receipt? They could only take those that were receipted. The ones that were not receipted, they said, no, we can't take this because it's going to be a problem. Because there, you're going to prove ownership. Not just ownership, but source of income. Because the onus is on you, the duty is on you to explain your riches, to explain your wealth. It is not the other way around. This one here now is what? you are guilty until you prove the other way.
No,
and that is why they've been able to what? Curtail corruption.
Okay, Uncle Sam,
Yes.
now I love the fact that you delve into this.
Yes.
And one of the things that the president said that, piqued my attention was the fact that, we have to support laws that we have to, do a reform or go into a reform that supports the economy. And that brings me to some of the laws that we have. Some people have argued that our laws are archaic, they are barbaric, they need to be reformed to suit the kind of life and, the climate that we are in, or the situation that we are currently in at the moment as Nigerians, as a nation. Now, don't you think that we should be focusing on reforming some of the laws that we have, and it could, in a way, make things easier for lawyers and also for citizens of the country who need justice, who come to, the judicial system as the hope of the common man in the long run?
Yeah, I'm sorry to say, if we focus on amending or, it's an amendment of the laws in order to bring them up to speed, it's going to be a difficult route.
Does it take that long?
The better option is for the judiciary to be also attentive to the happenings or the realities of the moment, because they are going to interpret the law against those realities. It's the interpretation that matters most. You understand? And the judiciary is not in any way limited in its power to interpret, because that interpretation is what? Putting the raw letters of the law against what? The facts and circumstances of the day. It is their job. And that's why, like the Supreme Court, being a policy court, can today say, yes, yesterday a woman is described like this. Today, no. The realities of today, this is what? The definition of a woman. That is how it's done in some other places. But here, we have what I would call, maybe unfairly, we like that supermarket mentality. We get so many laws. Look at our constitution. Our constitution is more than 10 times the Constitution of America, and yet it's not working. But what I think we should do, and the attention to we should do, let's emphasize that part of this reform is also to call on the public to have their eyes, not just have your eyes on the judiciary to intimidate them, but also participate in discussions and provide solutions and suggestions that are helpful to the system. You understand what I'm saying? We woke up as law students. There is no way as a law student, not talk of as a lawyer, I would have dreamt of I would have a problem of defining what is a marriage. You understand? But today, I would have to be a little bit cautious. Because what? There is one funny world order that is accessing us that say, oh no, that definition is no longer tenable. But for me as a lawyer, all I could do is to bring the attention of the court to that. Because what do we do as lawyers and what do the judges do? The law is that for every case that a person, an aggrieved person brings to the court, there must be a relief. So there is no excuse to say, oh, there is no law governing this. It's not an excuse to say, oh no, the old law can no longer meet this. No, that is not our job. Our job would say, irrespective of what it is, if the law say, wow, you should bring the moon to the ocean as a duty, we would say, if you take a look at the books, you take a look at the society, you will find the means. That is what we lawyers do. In trying to what? Draw the court, the attention of the court, and persuade them to look at this to get to these solutions.
Isn't this very cumbersome for the lawyers?
Yeah, that is why legal business is a serious business. It's not for, that's why when you see the difference between those of us in practice and those who are commentators, they are very fine-minded, very eloquent, because what? They don't have the problem of what we do. We know that, hey, yes, fine thoughts, fine discussional concepts do not matter. Because what matters at the end of the day, there is a problem. That problem, the law says, is in the books. That problem, the law says, is in the precedents. You have to find it. That is your job. And that is why you see all of those books, all of those midnight, we are looking for the law. You understand? So what we are saying, let our job be helped by a procedure, because when the disputants or the litigants come to court, they are bringing a dispute. That dispute, they want it to resolve like yesterday. But what do you have? Before you go to that dispute, the court is a mess in some procedures that they are not part of. These are what? The way of processing the dispute. If you don't have a good lawyer, your case dies there. Look at what are they saying? Somebody did not, what do you call it? Did not contest the primary, or is not fit to contest the primary. You know he's not qualified to get this state. You know, everybody knows that, hey, you shouldn't have been there. But the lawyer who took it took the wrong step. And the law says, you know that if you bring this case within this step, we do not have the power to look at it. And therefore, irrespective of whether or not that is the merit of the case, we cannot go there because what? We cannot pass this threshold. We have to pass this way. You put it aside. That is the problem. So we are now saying, let's look at these procedures. Let's bring them to reality, because what? Our colleagues next door, they have a better system. And that system is working and resonating with the public.
All right, unfortunately, we have to butt in here because this is the much we can take on this segment of the discussion. But definitely, it's a continuing conversation. And of course, we definitely hope to have you subsequently to continue discussions around reforms in the judiciary. With that, that's the much we can take on this segment. Of course, we're going on a quick break now. Thanking Leonard Essay and Sam Kargbo so much for his perspectives and opinions on the situation. Join us again after this break to serve you the newspaper headlines.